Good evening. This is Rahul Reddy. We're live here from Houston, Texas. We do bring in immigration updates, and we do have live question answers from 5 p.m. Central Time to 6 p.m. Central Time. Emily, what do we have today to discuss?
Today, we want to talk more about this SEVIS termination, what's going on with F-1 students who are getting random emails, number one, from the Department of State saying that their visa has been revoked, but now emails from their school saying that their SEVIS has been terminated, and that puts them out of status. Why is this happening? What's going on? What are people doing about it? What are the options? We also are getting a very common question from people who already have their green card and want to know, is it safe to travel? We are in the Trump administration. What are their concerns for green card holders to travel outside the United States? Should they be worried? And then, as these SEVIS terminations are happening, are there any possibilities of this spreading to other visa categories like the H-1B? We've had happen before where visas get revoked. People get an email from the Department of State, not just for students, for other visa categories as well. Is there a way that USCIS may now start trying to revoke approved H-1Bs or L-1s because the visa has been revoked? And then lastly, we want to go through the H-4 EAD auto extension, remind people what the requirements are for that. It's not the same as regular EAD auto extensions. So we want to make sure people know the extra steps they have to take in order to qualify for that.
First thing, I just want to let everybody know, I'm getting some disturbance. Let me see if I can.
One thing I want to know that there is no person has ever been picked up after the SEVIS termination has occurred. I just want to have the fears subsided. Nobody that we know have ever been picked up. If there is one guy I know, that guy got picked up because he had 2 drug convictions. He practically was a dealer in at least acquisition was that he was dealing in the drugs. So the normal people who were being sent this SEVIS termination and also notice from the U.S. consulate, I've never seen any other person getting picked up by ICE. I don't think so that they will do it. If there is any changes, we will inform you here, but I don't want you to live in fear that they're going to come and pick you up. You guys disagree or anything, Emily, on that?
Yeah, I agree with that. I think there's always that possibility, but it's very low likelihood. I think they're doing this more as just a way to get people to self-deport rather than having them go around detaining people.
Since we have Stephen Brown with us right now, as you know that our law firm is Reddy Neumann Brown, and Mr. Stephen is the one who's in charge of litigation. He is the one who did class action suit on the H-4 EAD, and he won on that where, it was until January 18th. Now, Stephen, of course, when we are getting these emails from the consulate, of course, they have been terminated from the SEVIS system. They are no longer eligible to work on OPT and STEM extension if they are on. And there are a couple of options that are there. Definitely, we discussed those options of reinstatement. Probably may not be a good idea because we are going to the same department again, requesting that, hey, save me, put me back in there, which they kick you out for the reason. That reason has not been eliminated right now. And of course, applying the court litigation now. Why don't you educate our audiences how and what is the best option when they have been terminated from SEVIS, Stephen?
Yeah, so typically speaking, there's 2 options. Most immigration attorneys are going to tell you when your status is terminated, depart the country or apply for reinstatement. Those are your 2 most common. We're going to talk about a third here in a minute. Reinstatement is probably the most easy thing we could be doing in this situation, but I don't think it's effective. And I'm more about finding an effective solution. The reason I don't think it's effective is you have 3 entities here. You have Department of State is terminating revoking your visa. Okay, that's Department of State. underneath Department of Homeland Security, you have ICE as a sub-agency who is terminating your SEVIS. For whatever reason, they've decided to do this. I think this is a cabinet level type decision that they are doing for political reasons. I don't think it's one or two ICE officers that are doing it. I think it's upper level. So when you're terminated, you apply for reinstatement through USCIS, who is a DHS sub-agency, and asking them to put you back in. You have to prove that it is that the issue causing it is outside of your control. It is discretionary, meaning they can make whatever decision they want. And USCIS, on its policy manual, has said we don't view criminal actions by the student as outside of their control for reinstatement purposes. So, the analogy I use is, you've got mom has decided to punish you with ICE, and you're going to ask dad to take away the punishment. I think they're lockstep in this, and I don't think that's going to happen. So we've been working since last week when this popped up on researching the legality of this so we can sue for students and get in quick with emergency motions for them, because we have time is of the essence here. And we've developed a litigation strategy. We're onboarding it. We are about to file some cases, I think tomorrow, for some individuals, and we are ready to go on this. So when we talk about the litigation, what are we doing? And I'll talk about it at a high level here. First off, we don't think ICE has authority to do this. Under the statute and under the regulations, I find nothing to support their decision-making here. Emily and I were talking this morning in the University of Northern New Jersey case, the fake school, the sting operation. The Third Circuit, the appellate court, said you don't have authority to terminate SEVIS in even that scenario. So when we talk about these minor criminal things that we're seeing, I'm going to use the term criminal because that's what they're using. I don't think they have authority. Let's say I'm wrong. Let's say they do have authority. There is not reasoned decision-making under the APA that is being done to have this final agency action. They're just terminating it for everybody. And then number three, I think there's a due process issue. You're not getting an opportunity to respond before they terminate you. So, look, litigation, I can't always predict outcomes, but I think we have good arguments here to not only file restraining orders and injunctions to get in and get decisions quickly, because time is of the essence. You're accruing. Look, there's a big debate amongst immigration attorneys. Is SEVIS really your status? Are you really unlawfully present? And look, I think those debates are very well and good. I'm looking at what ICE is saying, and on their website, they're saying you need to depart immediately when you're out of status. USCIS says that when you're out of status and you have D/S, you're beginning to accrue unlawful presence. So, if we file one of these cases and ICE says, no, you're wrong. You're still in status. You're not unlawfully present. Great. I'm happy with that. But I don't, we have to look what they're saying on Study in the State and what they're saying on USCIS's website. And then we can have that philosophical debate amongst attorneys about, is this really a status issue or not later?
So we are. What if we file the court litigation? This is going to be in the federal court, which is, it's the judge is appointed for lifetime, and they're not employees of the DHS, of course. Stephen, how much time limit? What is the time limit we are speaking about? When would you expect? I mean, nothing guaranteed, but when do you expect some result, though, when you're going to request for emergency motions?
With our strategy, we're not just going to file the case. Typically, the government gets 60 days to respond. That's not enough, right? Because litigation can be prolonged. We need immediate relief to preserve the status quo here. And so we are looking at filing temporary restraining orders, or in the alternative, motions for preliminary injunction, kind of as one motion here to get you back into that F1 status. And I'm hopeful, 2 weeks to a month we'll have a decision, and potentially quicker, right? We've seen some of these high profile cases where judges have issued restraining orders within the week. I can't promise that, but these are emergency motions.
What's your experience on it? Have you done any class action suits, Stephen?
Yeah, we've done a lot of litigation on a lot of different things. We've had emergency motions before. Some have worked, some haven't. Each case is going to be unique. I think this one is very unique, though, because I think it's very crystal clear on the illegality by ICE. I don't think that they have authority to do this whatsoever. And, look, maybe I'm wrong and we find that out, but I'm not seeing it. Other attorneys aren't seeing it. Other attorneys outside of our firm aren't seeing it.
We have put a link at the bottom of the video, guys. If you are interested, if you have been terminated from the SEVIS or you got the visa revocation email, if you are interested in court litigation with Stephen Brown, you can fill the sheet out. It's just basic information so that you'll get update from Stephen Brown about the actions, and if you're interested in litigation, he will be gladly able to help you out. Anything else, Emily, before we go to the next topic?
Yeah, I just wanted to ask Stephen. So, we have a lot of people that are facing the same issue with these revocations and the the SEVIS termination. Are you looking at filing this lawsuit as a class action, or does everyone have to do it individually, and why one way or another?
So, we've been talking a lot on strategy on this, and we've brought mass actions before with group cases, and we've brought individual cases. My concern with group cases is twofold. One, it gives the government an opportunity to respond with procedural arguments rather than arguments on the merits. I'll give you an example, Emily. We did a large case on H4 EAD in Nebraska with an emergency motion because people are losing work authorization. And the first thing the judge heard was the government's motion to sever them into individual cases. I don't think that these are unique cases. I know everybody kind of has their own unique background, but I know, I've seen this enough where I think that's what the government's going to argue is that, well, this person has a DUI arrest. This person has a speeding ticket. Judge, we have to look at all these uniquely. Everybody's got their own unique immigration story. Nobody wins when we fight on procedure. That's number one. Number two, I think, having mass actions also creates more pitfalls. Let's say, hypothetically, we've got a case with 100 people in it and someone's on a watch list. Well, the court might look at this case differently. Or maybe there is someone who's removable. They weren't very frank, when they were onboarding. So I think when we do individual cases, it allows us to be very quick for individual needs. And look, we've done mass actions before. They're easier. You could draw up a lot more business doing that way and, fight everybody all at once. But again, I think it creates some pitfalls that I want to avoid.
Anything else, Emily, before we move?
No, we can move on to the next topic about green card holders traveling. If I've been a green card holder for the last 3 years, want to go home to visit family, is there anything I should be worried about?
Absolutely not. The press is crazy about it. They are scaring people who report it. Absolutely, you can travel. Now, there are some rare exceptions, guys, that we have to mention it. If you are going outside the country for more than 6 months, more than 180 days, we definitely want you to check with a lawyer. We don't want you to travel without checking with a lawyer. The second is that if there is any criminal records other than traffic tickets, we definitely want you to check with a lawyer before you travel. But if you are just a Tom, Dick, and Harry, just a normal guy, and you're traveling for the summer vacation to your home country and you're going to spend there anywhere between 10 days to 3 months. You absolutely don't have to worry about it. There has never been a single incident where they have been stopped, deported, or anything like that. Now, the press doesn't give all the statements, guys. The reason is that we, as a practitioner, sometimes we get to know these things. They call us and they inform that, you know, I have like 3 DUIs, or they have some drug convictions and they're traveling outside the country. Or there are some people who have been coming, they have a green card, but they've been only coming into the country every year, only once. And when they do come here, they have a return ticket to go back within 1 week. So green card is for a person to stay in United States, so called permanent resident of United States. If they are staying outside the country and they're visiting inside, the immigration authorities do have, they can deny entry into the country. Have you seen any different, Emily?
No, I agree with that. I think there's been a lot of reports of, Indian grandparents being denied entry on their green cards and that the government is targeting them. Well, this has been going on prior to the Trump administration. It's not anything new. The law hasn't changed. They're not implementing it any differently. Maybe they're a little more strict now than before, but the general rule is you're supposed to be living in the U.S. and visiting outside the U.S., not living outside the U.S. and visiting into the U.S. And so those are the situations where people have been stopped because they have basically abandoned their permanent residence. They've abandoned their green cards and they're not going to be allowed into the country. That and actual criminal issues, criminal convictions, not just arrests for major crimes. Those are what you're hearing in the media, not just your random, normal, everyday green card holder.
The next topic we're going to discuss is that we have seen that we have told people who have some, minor criminal things previously that they will not be suspended from SEVIS system. At the most, their visa may be revoked, but they can still get the OPT stem extension, and also they can get the H-1B. That has been going on for a while, and recently now we got this for minor, even traffic ticket. If they did not pay the traffic ticket, they got an arrest warrant. If their auto insurance expired, they got detained, and now their civil system has been suspended. We did not expect this. Believe us, for those people who contacted us before, we said everything will be fine, but now things did not turn to be very good. Now, Emily, could it be possible that the same thing can happen to the H-1B workers who have not paid, who have paid 1 day late the speeding ticket? Or maybe their insurance expired and they were being caught. And let's say insurance expired on July 1st, and on July 4th, they were driving the car and they got caught and they were been, detained for a while and before they have been released. Could this happen with the H-1Bs, H-4s, L-1s, O-1s, P-1s, Q-1s, R-1s, and all other non-immigrant visas?
I think with Trump, possibly anything is possible, but I think it's very unlikely. I don't want people to be afraid that this is going to spread beyond F-1 students. And the reason for that is it takes a lot more effort on the part of Department of Homeland Security to end someone's status when they are on an H or an L or an O or a P or Q or whatever the visa is. And the reason for that is they're petition-based, they're employer-based. So, prior to all of this happening with F-1s, if the government's doing site visits for H-1Bs, and if they find something not right during that site visit, they don't just send a notice saying we've terminated your status. They can't do that. They have to send a notice of intent to revoke. Then that gives the employer and the employee 30 days to respond. And then based on how they respond, they have to issue a reasoned decision explaining why they're now revoking the petition and therefore the status. So it's not something they can just kind of automatically do with a click of the button like they can for students on in the SEVIS system. So with SEVIS, there is no petition filing. There's no employer involved. Even for OPT, the employer is not really sponsoring or anything like that. It's just very easy for them to take that action for students compared to any other work visa. So again, I think anything is fair game when it comes to immigration and the Trump administration and Stephen Miller, but the likelihood of any of it spreading to other work visas is very low, in my opinion.
However, I would recommend that if there is any criminal records or arrest records, this is not the right time for you guys to travel, guys. This is not the time to go for the drop box. This is not the right time to even go to Mexico and come back. This is not the right time. I definitely want you guys to wait. And we will get the reports from those people who travel outside. If they were able to come successfully, then we'll inform you at that point of time. If they failed, they had some problems with the stampings and other things, then we'll inform you. So give us some time so that we can get more knowledge on this before we pass that knowledge to you. So we have a lot of audiences. We have been there for a long period of time. So we will get the information from the people. And when panic comes in, guys, we have also noticed Emily and Stephen. I've also noticed some fraudsters now sending fake emails asking them to pay the money. And they will be, they cashed in on this one. I got an email saying that, hey, you pay some money, everything will be closed within 2 days.
Yeah, I think you have to be very careful in these times. People want to try to take advantage potentially of it, whether it's, oh, hey, well, we could get you a reinstatement I-20 tomorrow, and then you just apply for reinstatement. We've got this day one CPT school. It's awesome. Just be cautious about some of these things if it sounds too good to be true. And we know both the Obama administration and Trump 1 put together sting operations, right? University of Northern New Jersey, University of Farmington, and they got pushback in the court system, but lots of headaches and issues with that for people. And I just be cautious with taking actions like that that could jeopardize your future here.
Okay, we go to the last one, Emily. Auto extension of H4 EAD. When I am, let's say my H4 and EAD is expiring in August of 2025, and I filed H4 and EAD extension, and if the H4 and EAD extension is pending, isn't there a rule that if the EAD extension has been filed before the expiration, I can work for 540 days after August 1st of 2025? That's when my H4 and EAD is expiring.
Yes, but there's a caveat, because just filing and having the pending EAD application and the pending H4 application is not enough. So yes, there is an automatic H4 EAD extension of 540 days, but it's not actually automatic because it only works if your H4 has already been extended. So you either need the H4 extension approval notice, or you need to get a new I-94 that extends your H4 beyond the period in August in this example. So if I filed those two extensions now and August rolls around and they're still pending, yeah, you have a pending I-765 and you filed it before your EAD expires, but your H4 is also expiring in August. That does not allow you to extend further. So you have to get the H4 approval, or you have to travel and get a new I-94, either by going for H4 stamping or potentially using automatic revalidation. If your spouse's H-1B has already been extended, we might want to be a little bit more careful about those situations, especially for people who have any kind of arrest issue in the past. Probably might not be a good time to seek those options, but it's automatic, but it's not really automatic.
Yeah, and if I could just add something here, both of y'all mentioned concerns about travel versus being in the U.S., and I think it's worth explaining real quick why. When you're in the U.S., you have a lot more rights with your immigration than you do at the consulate or at the port of entry. When you're at the consulate, nobody can really review a decision from the consulate. So if they deny your visa, we can't challenge that in federal court. The consular non-reviewability applies. At the port of entry, when you have expedited removal, there are administrative steps, and we are kind of exploring maybe some litigation that gets very unique in those. But as it stands right now, the case law is you can't challenge that. you would have to apply for a waiver, and that can take a long period of time. So when you travel, there's more discretion that the agencies and the officers have that immigration attorneys, litigators, they can't fight versus when you're in the U.S.
I'm going to go to some questions, guys. There are questions from VVM. His wife is a green card holder, and she is traveling. She is coming back to USA after 5 months. That's good. Do you see any problem in the DFW airport? No, I don't see any problem. Make sure she's coming within 180 days. If she's coming after 180 days, you contact an immigration lawyer. Since she's coming 5 months, it's under 180 days. I don't see any problem at all for her. For all those people who are outside the country, guys, make sure they come back within 180 days, unless you have a re-entry permit. That's a different issue if you have a re-entry permit. Question comes from Hardik Patel. Advanced parole travel. Are you okay with people who have advanced parole traveling? Do you see any problem? No, we don't see any problem. There were some people who got panicked when they're being sent to secondary inspection, soft secondary inspection. That's normal. We have been telling about that for a long period of time. That takes extra 15, 20 minutes to clear for the advanced parole, but no problems for the advanced parole people. You guys can travel and come back.
And when you say the secondary inspection, I think we've seen some officers who confuse advanced parole with like the CHNV parole, but once you get a talking to, I've not had any issues even during the Trump administration with advanced parole. So that's good. There's a question from Nikki here. Reports about student visas getting revoked for small offenses. Makes me wonder if listing or selling old items on Facebook Marketplace would be an H-4 violation. I don't think so. I don't think you're working, if you've got an old bicycle sitting in your garage and you're putting it up on Facebook Marketplace, that would be a huge stretch to say that that's violating your H-4.
Ken Canalar says, what do you recommend for these SEVIS terminated students? What are the chances of approval for all the different options? I hate to give you the lawyerly answer, as we kind of don't know. But that is the truthful answer, because this is brand new. We are in uncharted waters. We've never seen ICE take this action with F-1 students. So will reinstatement work? We don't know. I think our opinion and the opinion of many attorneys is probably not, because as Stephen said, it's like your dad, which is ICE, said no. So you're going to go turn around to your mom and expect them to say yes, which is USCIS. No, they're going to say no too. It's a united front. This is Department of State. This is ICE, which is under DHS, and this is USCIS is the one that handles reinstatement, and that's also under DHS. This seems to be a concerted effort. Seems pretty unlikely that reinstatement is going to work. What about just, getting a new I-20, traveling, applying for the visa again and coming back? Well, I think they want you to leave the U.S. And that's pretty clear with the Trump administration and Stephen Miller. Legal immigration is bad just as much as illegal immigration. So if you leave, the chances of you coming back by getting the new visa, I think, are quite low. Even if there's nothing that makes you inadmissible, which are reasons they can actually deny a visa, the chances of you getting stuck in administrative processing, 221G, is very high, because they're going to say, we need to look into this person's background. There's an arrest in their background. We need to look at the criminal case and all those things. They're just going to sit on it forever and hope that you give up. So I don't think that's a great option. Filing a change of status to another visa category, the problem is you have to be in status at the time you file. And so if the ICE and USCIS think that when your SEVIS record is terminated, it puts you out of status, then you're not in status at the time of filing a change of status. That means you have to do a nunc-pro-tunc request, asking them to overlook the delay in filing and your gap in status and put you back in status. That is up to their discretion. USCIS is probably not going to use their discretion to approve that for someone who lost their status because of a criminal issue. So that leaves us with lawsuit. And again, we don't know if it's going to be successful. There's no way we can guarantee that. It is a completely new cause of action, completely new legal theory. We're on the cutting edge here. I think we have very good arguments, but we just can't say which is most likely to be successful.
This is a good question from Manasa, and this question comes up very much, and I think so we need to have a debate, Emily, on the YouTube, that of course there is, we don't, when people are coming from the airport though, they do not have a right for lawyer. They can't have a lawyer represent them and speak on behalf of them. What are their rights though? What can they refuse giving the cell phone to them? Can they refuse speaking? Then can they take the Fifth Amendment? What other rights they have when you are being cornered? Because I had a client that I spoke to today where they forced her to say that the company has paid the money. She said the company paid the money, but they wrote it down as that she paid the money to the company. The company has paid the money to the immigration. They asked that, how much the company paid the money? Well, it's $2,000 or $3,000. And it said approximately 2-3, because that's how the filing fees is. And they said you paid the money, and then they reported. Sometimes whatever you speak, they're going to take against you. That's the reason we have this Fifth Amendment, the right to remain silent. Can they take that? And what are the rights people have? And they are asking for the cell phone, the WhatsApp. There may be a lot of private messages, unnecessary messages that may be misinterpreted in that.
Yeah, I think the problem is that, yeah, you always have the ability to say no. You can say, I don't want you to open my cell phone. I don't want to incriminate myself, so I'm not going to say anything. But that is you're by allowing them to do these things, and it's in exchange for them letting you in. So they can just say, well, if you're not going to provide us this, if you're not going to let us see your cell phone, we're not going to let you in. So we're going to deport you. So you really have to decide whether it is better to comply with them with the chance that you might be allowed to come in, or not comply with them and take your chances of the likelihood of you just being sent back.
So if, when you're very uncomfortable though, you can always request, I want to withdraw my application to enter into the United States. How does that sound, Emily? They can always fight back the things later on applying for the visa.
Yeah, I definitely think that is a good option because you don't want to get into a situation where they're taking a statement from you that creates a misrepresentation or something that they can use against you in the future. So if you just withdraw your application for admission, yes, you do go back to your home country, but at least there's no decision made, there's no finding made that you've misrepresented something, which is what gets people into a lot of difficulties. The other thing you're potentially avoiding is what we call expedited removal. So in those situations where you're coming into the US and they think you're not qualified for whatever reason, instead of you withdrawing your request for admission, they can give you expedited removal, which is basically a fast deportation where you have no access to an attorney, you have no right to go before a judge, and it comes with a 5-year ban. So it's a very extreme response. And so if you can instead withdraw your application for admission, then you live to fight another day. You don't have to worry about this 5-year ban. You might have to apply for the visa again, but there's no misrepresentation. There's nothing that is now making you inadmissible to where you can't get a visa in the future.
Yeah. And, I know a lot of people are asking about an attorney. I mean, I've called, while a client's in expedited removal before just to check on them, and they won't give you much information. You have no right to counsel at the port of entry. Somebody asked about the ombudsman's office, if they've suspended it. Yeah, I've seen that story. USC. My understanding is that they have basically fired everybody from the ombudsman's office who isn't the ombudsman, because the ombudsman, the person with that title, that is a statutory requirement. I had somebody ask today, do you think it's worth going to the ombudsman? I mean, sure, it's free. It's not going to cost you anything. Are they going to help? I don't think so.
Is it good time for going for H-1B stamping? This question is coming from Mayush. Dropbox. If you're going for Dropbox, yeah, maybe it is, because afterwards you may lose the Dropbox eligibility, as long as you are working directly with a client, not with consulting companies. Then probably it may be good for you to go right now, because later on, if you want to go, then you won't be eligible for Dropbox. Question from Nimish. Visa stamping in Mexico. If I don't get the visa stamping in Mexico, can I come back to United States? No, you cannot come back. If once your visa has been rejected, though, you cannot come back. Your automatic revalidation is not valid. Even if you have the passport visa, that will be canceled automatically for you to come back to the United States. So you can't come back if the visa has been denied, or if they issue a 221G there, you cannot come back. You will have to go to India. From there, you have to make another application to come back into the country.
Question from Varun. I'm on green card EAD, and if my 485 is rejected for any reasons, will I be unlawfully present from the day that it's rejected, or will I have time to resolve the matter? So I think you start accruing. If you are completely married to your green card and not maintaining that underlying status, I think once it's denied, you begin accruing unlawful presence once it's denied. There might be some options, but even filing an appeal doesn't toll that. Frankly, though, we don't see a ton of 485 denials. I mean, we've handled a few lawsuits on them on very weird issues, but it's not like it's a common thing.
Harini has this. She has an advanced parole valid until July 2029. Changed the job, applied AC 21485J. Is it okay to travel since the 485J is pending? Absolutely not a problem. You can travel.
Vivek says, what is the approval rate for H-1B visa extensions? My I-140 is approved and I've applied for the extension. Will it be for approved for 3 years? Yeah, we really have not seen any issues at all with H-1B extensions, H-1B transfers. They're being processed as before with an approved I-140. If your priority date is not current, you can get that for 3 years. No issues with that as of right now. That may change as we get further into the Trump administration. We definitely saw big impacts on H-1B extension applications during the previous administration of Trump. So that could be coming, but as of right now, no impacts.
Yeah, I haven't had any issues yet.
Any news on the OPT law, Emily, where they're trying to remove the OPT completely?
I have not seen any updates on it. I will try to check for that while we're here.
That's a good question. I want to go pull that up today.
As what I was speaking about is that there is a bill that has been introduced in the Congress where the bill wants to eliminate the complete OPT. If the OPT eliminated, the STEM extension automatically gets eliminated. We're not expecting it to be passed. We just want to update you what's going on that right now.
I am not seeing anything. I see that it's the same 8 sponsors, the who's who of people, and it's been referred to committee, but that's it.
Yeah. Nothing is going on. That's good, guys. And refuse. Is it safe to travel on a refugee travel document? Absolutely not. This question is coming from Amunu Yelma. No, not safe to travel on a refugee travel document right now.
We've been receiving.
I can't hear you, Emily.
We've received
Can you hear me, Emily?
We can't hear you, Emily. I hear you vaguely, but I don't know if it's a microphone issue or what. So question that it was asked here while we try to get Emily to her microphone back. H-1B for fiscal year 2026, second lottery, any information? They haven't published any information about the numbers, and we won't know about a second lottery until this summer.
If the if the F-1 has been revoked and there are people who have a H-1B who has been picked up, what's the option there? Definitely, you can file H-1B with the consular processing. You have to stop working right now. That's one thing that you have. And the problem is that by October 1st, you will be accumulating 180 days of illegal presence. So if you stay until October 1st and then you leave the country to get the H-1B stamping, though, then you may not be able to come back. Either you take an action right now, okay, either you file a court case or probably reinstatement, which may not work, you can try. But all these things, the court case, the reinstatement, will not pause the 180 days of illegal presence. And let me explain you what 180 days of illegal presence is. If a person is illegally present in the country for more than 180 days, there is a 3-year bar that they cannot come back into the United States. And if it is more than 365 days, there is a 10-year bar, they cannot come back into the United States. Now, most of the people, when we see that the SEVIS has been terminated, between April 1st and April 5th, most of the SEVIS has been terminated. So if you go all the way to October 1st, though, it may cross 180 days. Once it crosses 180 days, though, then even if you go for stamping, you may come under the 3-year bar. So either the company can file an H-1B in the consular processing. You may try to do the efforts that we were discussing about litigation, reinstatement. If the things don't work out, normally I'm telling people that they should leave the country on September 20th, because that's almost like 170 days by that time. Do you agree with me, Stephen, on that? What if you take the litigation and then you don't get it, we don't get any results?
I mean, go with the litigation with the way we're doing it. You'll get, options real quick. I mean, you can still file for reinstatement after if you really, really want to. You can depart. But I don't, watch that 180 days for everything.
Emily, does filing a reinstatement, does it pause the illegal presence? Because the clock started on April 3rd. When we file a reinstatement, does it mean that it stops or it continues?
It doesn't stop it unless it's ultimately successful. And that's the difficulty, is the processing time can be long and there's no premium processing for it. So it's very possible that while you're waiting for that reinstatement to come through, you cross the 180 days. And then after that, if the reinstatement is not successful, now you have very few options. And now you've crossed 180 days of unlawful presence. You're going to be found inadmissible for the next 3 years. I think there's also a problem with, for those that have been selected in the H-1B lottery, if you're thinking, well, my SEVIS is terminated, I can just leave and then I'll do consular processing and apply for the H-1B visa. I'm concerned that the H-1B visa stamp is going to be put into administrative processing because of the same criminal issue. I think this whole point is to get as many people as possible to leave the U.S. on their own and then close all the opportunities for them to come back. So it may be a better option, at least when you're filing the H-1B, because we're working on those now. We have until June 30th to file. And so we're kind of flying blind here. We don't know what's going to be the situation with these F-1s come June compared to where we're at in April. So if you're filing your H-1B now, it may be a better idea to file it with the change of status and hope that things are resolved before they issue that decision. The worst thing that will happen is if they think that you are out of status at the time of filing because of the SEVIS termination, they'll send a request for evidence. It says, prove to us that you've maintained your F-1 status. Once you get that request, you generally would have 12 weeks to respond. So you can maybe hold off on responding to that, see what's happening, and then see if you are able to successfully respond or if you need to convert it to consular processing at that point. Again, keeping that 180-day rule in your head. You don't want to go over that, even though you've got a change of status pending, because that also is not tolling any unlawful presence. But I don't know if I would go straight to consular processing my H-1B right now.
Question from Carolina Raju. I'm a Canadian on H-4EAD. I'm planning to travel end of April. Do I need to file G325R? If you are the spouse of the, you're on H-4EAD, that means that you are a spouse of H-1B. So definitely you do not need to fill the G325R. There are some children who have turned 14 after they came into United States legally. Those are the only people that are required to fill the G325R. I'm only speaking of the legally present here people, though. I'm not telling about those people who are illegally in the country. Since you are legally in the country, you are a H-4EAD, so you did not come in as a 14-year-old kid, so you do not need to fill the G325R at all.
Suresh says, I recently changed from H1 to H4 with an H4 EAD. I have valid H1 stamping till February 2026, and I'm planning to travel to India. Do I need to go for stamping because my status has changed? Yes, you do. I mean, if you want to come back on H4, you need an H4 visa to come back on. If you want to come back on H1, you need to have a valid H-1B petition and a job offer from that company in order to use the H1 stamp. But you cannot use your H1 stamp to enter in H4. Because you need a visa stamp, I would say now is not the time to travel. So you need to really weigh the pros and cons and the reason for your travel to decide whether it's worth it or not to potentially be stuck outside the country for an extended period of time.
Question I saw is about the Department of State pilot program for stateside visa processing. We've seen nothing on that. So if we get any updates, we'll do a special session on that.
Aditya has the question which I want everybody to listen to. He's just asking, he's not doing it. He's just asking, can he do the Dropbox while staying in United States? Can he send his passport to somebody to the Dropbox so that he can get the visa stamping without ever stepping outside the United States? That is crime. No, you can't do that. There was one incident where they did it. They caught that guy and they barred him forever coming into the United States. You cannot do it. For the Dropbox, you have to leave the country. You have to go there in India. Yes, while you're in India, you may have somebody else drop your things if you can't go. But you cannot be in United States to drop the documents in India.
A couple of people have been asking, they had an arrest previously for something minor or a traffic ticket or something like that, but their SEVIS record has not been terminated yet. Should they be taking any action? Now, obviously, you can't go back in time and undo the arrest. It's out there. So it's possible that it's coming. We just don't know. We don't know what their criteria is. We don't know how long this is going to keep going for. We don't know if we can stop it or change their policy through litigation before they get to you. But if you're concerned about it and want to avoid the potential, you could proactively file a change of status to some other visa category. Like maybe your spouse is on H-1B and you qualify for H-4. You may want to stop F-1 and switch over to H-4 so that you don't end up in this situation where your visa gets revoked and your SEVIS gets terminated, putting you out of status. Because once you're out of status, it's much more difficult to get back into status. But if you file that change of status before anything happens, if you have an option to do that, that may be
and it might be something to consider filing online. And, maybe you think that's silly because, hey, as an attorney, I can't file for you, but the I-539 is super easy to do and you'll get the receipt right away. And so instead of saying, hey, if you file on paper with an attorney, there's mailing involved, right? If you go online, you get the receipt right away. That way, if your SEVIS is terminated, you've already been proactive. Question here. Do you have any successful litigation for STEM? Maybe not you or your lawyer community. I mean, I filed lawsuits on STEM denials that have been successful. This whole issue with the SEVIS being terminated is brand new. I think it's within a week. I think there's been a couple of cases filed. I know there was one yesterday out in California. They did not file an emergency motion when I checked the docket today. So there's been no results, but I can tell you a lot of people have similar legal thinking on this.
I just want to discuss a couple of cases, Emily and Stephen. There are two cases that I had consultation with. One person had a DUI, and after the DUI on F-1 visa, the person had to extend the F-1 visa because he was doing a doctorate degree. He went to India, got the F-1 approved after the medical examination, and then came back, and his visa was his service has been terminated. There was another child, he's like 21-year-old kid from Dallas. He also had the same, where he was being detained just because there was some complaint that he was having open alcohol, which when they found out that he was actually drinking Coke or Gatorade, something like that, not alcohol at all, which is perfectly legal to drink Gatorade and Coke on the open. And when he went to get F1 stamp, he was an H4 when this incident happened. He went and disclosed that information, got the F1 approved, and then came back into United States. He got his SEVIS terminated right now. So this question is asked here by Rahul, that I came back after my visa has been revoked. I went and got the stamping done. There is still a danger for your SEVIS system to be suspended if you're still on the F-1 visa right now. Any concerns, Emily, about these two things?
Yeah, I think it's just because you've already gone and got the visa, we have a new administration, new head of, Secretary of State, new people in charge. And so just because they gave you the visa before doesn't mean you're in the clear. You are definitely still in danger of getting this terminated again.
I had somebody that I talked to today traveled, had the DUI before, traveled, got the visa. Now they're back in, and now their SEVIS is terminated again. Like, what are we doing? But it's happening. Shoot, we saw someone who there was an incident at the house because the police decided they were going to take both people into custody. Then the F-1 student was released, and they said, you were the victim. You were the victim of domestic violence. But because she was brought in and fingerprinted, her sentence has been terminated. That's the only run-in she has had with law enforcement. And I'm going to not get too heated, but that's garbage. And, we're seeing it for things like that. We've seen it for speeding tickets. We've seen it for a lot of little things that would not make you removable, would not make you inadmissible, are hardly crimes, in terms of the real criminal, but I think it's being done politically.
I think so, not only politically, Emily and Stephen, I think so it's done by a computer, though, that anybody has a arrest record. They didn't look into it if she was a victim or if she is the culprit. They just put the button. She had an arrest record. That's all, whether she's a victim or not. So it's done by computer. That's all I'm thinking. Probably it's done by Elon Musk. That's the way I'm thinking about it.
Yeah, I was just going to say that. I mean, that's exactly when they were cutting things at, what was it, HHS, and they came across transgenic mice that are used for cancer research. They assume that that's transgender something or other. And of course, we're anti-DEI and anti all of that. And so we're just going to cut it based on that terminology that they have no idea what it means. I think this is
they did it with Jackie Robinson, the baseball player, on articles on him on the DOD's website. I don't think this is being reasoned decision making. I think it's whatever AI they're checking on the database, the FBI database, all that shows Emily had a run-in with the law, so cancel her visa. Done. And with SEVIS, it's as much as clicking a button to terminate it. It's not like we said with H-1B where they have to send a notice. That's why I think it's very different circumstances for H-1B holders.
Sujit says, my H-4 change of status has been approved. Will there be any issue in visa stamping as I have to travel at the end of the month? And you're at your own risk here. We are telling people if you need a visa stamp, now is not the time to travel. If you are in the US and need a visa stamp to come back, because once you're out, there are no guarantees. If you qualify for Dropbox, they're all of a sudden telling people, no, you can't do Dropbox and you have to come in. We saw that happen without any notice because they changed the Dropbox rules. They could issue 221G. They could just decide they need to do extra administrative processing, even if you have no issues in your history. It is just a very big risk to travel. So I would say really reconsider the reason for your need for travel and decide whether you think it's worth it or not for that risk.
Somebody's saying ramify. He's saying that, hey, these are all not minor traffic interactions. These are major DUIs and shopliftings only, but not traffic violations. No, not true. We have so many things. The traffic violations, we have seen red light not there. We have seen people driving with Indian driving license that have been detained. We have had situations where people ran the red light and they got traffic ticket and they were being detained briefly, and they also got those things. They had one child from Boston, a very good university. I don't want to name the university. His visa, not the visa, the MasterCard and Visa, did not accept the payment, the monthly payment that's supposed to go to the insurance company. It didn't went through. The auto insurance lapsed, and he was driving and he was detained because the insurance says it's valid, but actually it's lapsed because of the payment of the credit card. It lapsed, and that's the reason why he was being detained. Now he got the service suspended. There are so many stories, guys, that are not good at all.
Jogesh asks, I'm a full-time employee. My H-1B stamping expired June 2024. Is it better for me to go for stamping before my Dropbox eligibility ends? Again, if you need to go for stamping, now is not the time. Don't purposely go for stamping so that you can potentially use the Dropbox. Wait until it's safe to travel. Just going for the sole purpose of being able to use the Dropbox. I mean, we would say no 12 times. Do not travel if you need a visa stamp right now.
I think people confuse. Like I talked with people last week. I mean, my visa stamp is expiring, so I got to go travel and get it renewed. No, you don't. That visa stamp is your ticket into the country. It only governs your entry into the country. While you're here, your I-94 governs. So if you file extensions, if you file changes of status, whatever, that is what is governing, not the visa stamp. You only need that if you travel. So don't think, oh, my visa stamp's expiring, I got to go, back home and renew it. No, you don't.
Hemant Tumala is asking, if somebody has a speeding ticket, they were never been detained, fingerprinter, never been charged any crime, and they paid the ticket or they went to court to get it dismissed, were their service terminated? No, I've not seen that.
Somebody on YouTube asks, are they still issuing U.S. passports for kids born after February 19th? That's the birthright citizenship. I have a guy that I interact with quite a bit, had a baby on, I think, I'd like to say it was right around that time, has the birth certificate, has the passport for the kid. He was very worried about it early on, but they are still issuing them. That's the way things are. It's teed up at the Supreme Court. I don't think it's going to go well for the administration, but we will see.
Okay. Anything else, guys, before we close?
It looks like we are out of time. Thank you all for joining us. If you would like to get more specific information and one-on-one consultation with us or any of our attorneys, you can go to rnlawgroup.com, click on the button for consultation, and you can book that online.
And
to
if you
speak
want to
with any
get
of us.
into consider litigation as a thing, I have given, and you want to get in touch with litigation with Stephen Brown, there is a Google document where you just fill the basic information, then our team will be in touch. So it's provided at the bottom of the video, guys. Thank you.
Thank you.